I did a video earlier talking about my prohibition against using ChatGPT and other AI tools in the practice of law. There are just certain things certain secrets about life and about humanity that cannot be duplicated. And how the mind process information and able to pivot from a thought um, cannot be duplicated. It's a secret. It's you can the machine the computer is only an imitation of how the brain operates naturally, and so man in its effort is trying to evil man is trying to replace humanity with machine. And it's just not going to work. God is not going to let it work. And here's a prime example why lawyers should not be using Chat GPT. This is it. This is why. If the platform is not within a legal platform, subject to rules of professional conduct, subject to the laws of each state, like Westlaw, Lexis. I think Westlaw is no longer, it's just Lexis, whatever it is now. Those tools, those people, if you get your information from there, that's one thing. They're even offered to show me AI. I don't want to use AI for anything. I love using my brain. But lazy people who want to get over, who want to do as little work as possible, are getting caught up. So here's a prime example of why lawyers should not be using Chat GPT. Okay?
Versus Banks case. I cannot find any case by that name.
Neither could my staff attorney, and she started to question herself. She's fairly new, and I said, "No, you've done this before, so let's just ask questions." So, Mr. Gillespie, none of the cases made sense.
Sure, I'm pulling it up right now. Just bear with me one sec.
And in all fairness, I'm going to tell you, I looked you up, so I know you practice in several jurisdictions. I'm not sure if this is something from another jurisdiction, and maybe it's their case law, but it's not Georgia.
Yeah, no, I have this as a Georgia Court of Appeals case from 2008. The Zoom is sucking the speed out of my computer. Hold on one second. I'm trying to actually pull up the case itself. Hold on. So the site I have is Kaplan v. Banks, 289, Georgia Court of Appeals, 193, 2008 case. Got some quotes from it. The big one is on page 194. The negligence of an insurer in failing to answer a complaint on behalf of its insured does not constitute.
One thing she did mention that this man is licensed in several jurisdictions, and I know you can, if a state has reciprocity, you can just waive in to the state and not have to take the bar exam. They also talk about some universal bar. You take it and you're barred in all states and stuff. I just have a major problem with that because each state does have its own set of laws and ordinances and things. Yeah, there's federal, but there's also state, and each jurisdiction varies. And you have to know the nuances of that local jurisdiction. So, yeah, she brought that up. I thought that was a good thing to mention because, like I said, you have all these people who are now barred in several states, but, they don't know the local nuances because there's a lot of information to comprehend. So, let's continue.
providential cause or excusable neglect under OCGA 91155B. And
All right, Mr. Kennedy, tell me where you had issues, and then maybe I can tell you where I did.
As far as the citations go,
Yeah, because the case law, like I said, I wasn't, some of it just wasn't adding up, or I wasn't able to find the sites that
Right.
were listed.
so that first one, that Kaplan v. Banks, was the first one that I noted that I just couldn't find either a case by that name or that citation to the Georgia Court of Appeals went to a different case called Hightower versus Cervantes, which analyzed the timeliness of an appeal and had nothing to do with what it was cited for in the brief. The Rowland versus Say case, 213.
So what they're pointing out is that in this brief, they were arguing certain motions. So you have to present a brief, and the brief contains your arguments along with the case law that either supports your argument or dissents from your argument. But you put it in and you argue why your case is either unique, it should be followed, or a particular finding of the court, how your case is distinguished or consistent with the findings of the court. So that's what a brief does. It argues, it's your argument on paper. And what the judge and the opposing counsel is pointing out is that those cases he cited and argued in his brief were not actual cases. Let's go.
Cited as 213 Georgia App 679. My note on that was that it doesn't talk about anything that was in the Penn site in the brief. It was about abuse of discretion in allowing a defendant to withdraw admissions, and that an occupant of a trailer assumed the risk of injury by walking over a defective floorboard. Nothing about an insurer or agent, not a valid ground to open default. The Henderson versus Quadramed Corp case, I actually cited in my brief for, I think, pretty much the opposite of what
Okay, so I'm gonna just fast forward this. So he goes through, and there were not just one or two, there were several cases, okay, that this attorney cited in his brief, and they were not actual real cases. Now, what I think happened is that, he relied on ChatGPT or whatever AI tool he used. He relied on it and he didn't check it, or he had some law student or paralegal prepare it and didn't go over it. You can't do that. Not especially when your license is on the line.
where the responses to my motions get filed within an hour or two. And I'll just go ahead and tell you, this isn't before you at the moment, but I did file a motion for summary judgment. In that response brief, I was noticing some of the same things. And I know Mr. Gillespie he's been suspended from practicing in Maryland before. And again, I'm not trying to cast aspersion. I'm just telling you, he's been suspended in Maryland, and part of that was for lack of candor.
Where is he?
So the attorney has been suspended in other jurisdiction. I don't know what for, but this is getting worse by the second. Okay, it's getting worse. Oh my God.
It appears that he either dropped off the Zoom call or lost internet connection.
I got knocked out. I think I'm using too much of my computer's bandwidth or something right now.
So, Mr. Gillespie, I'm a former staff attorney for 2 Superior Court judges. So, the staff attorneys I'm privileged to work with are really, really thorough, and we check everything. And so my concerns are that not just that we've had some very well-publicized cases where I guess ChatGPT or whatever the legal version of the AI research and writing platform is, but we've had some issues with that where even judges have been dinged because they've, instead of using good old elbow grease and eye shine, they've resorted to using the platforms. And what concerns me is you're in about 30 different jurisdictions, I swear, between the federal court, 5.
Wait a minute, 30 jurisdiction. You can't be effective being barred in that many jurisdiction. While it may give you bragging rights, there's just no way. Okay, no way.
Different states. I'm a second generation lawyer. I practice in one state because it's easier. You get to know everything. You don't mess up. I had to discourage my uncle, who's a lawyer, from practicing in federal court. I was like, the timing's different. You're old school. You got to practice where you know and where you can be proficient at all of the rules. And
we saw that with the YSL case. We saw that the Fulton County Prosecutor's Office was out of their league. And you had attorneys who practiced on a federal level as well as a state level, and they ran in there and embarrassed all of them. Everyone that came up before the court and represented the state in the YSL trial, they look like they just came out of kindergarten compared to the defense attorneys.
And so my issue has always been attorneys need to know the rules of where they practice and be proficient in that. And it's hard to do when you're in 5 different states, 27 jurisdictions in the federal court. So what I'm saying is, just listen to me.
Yep.
You risk a reputation, and as lawyers, that's really all we have is our good name and our reputation when you are trying to do too much. And so this brief concerns me because your client is owed a duty of representation, and you owe a duty to be true to the rules of the bar when you raise your hand and swear the oath. And I just need to know what's going on.
Totally understand. And I don't know how to move forward from this other than happy to.
He was clear. He knew not to make any confessions on the record. He knew. He was smart enough not to explain what happened because he know his butt is in trouble. I will link this video. I think every attorney, every paralegal should look at it. And this is why I have a prohibition against using AI tools. Have a nice day. Hugs. Bye.